University. He was a Dean of the Faculty of Law and Head of the Department of Law, Calcutta University. He was a member of Senate and Syndicate, Calcutta University. And it goes on, like there is a very long list of what Sir has done. It will take almost entire hour to do. So just going on. Sir has obtained his PhD degree in law from Aligarh Muslim University and passed LLM from London University, securing high marks in one of his papers. Sir has passed LLB from Bombay University, securing gold medal and prizes. Sir, I will really welcome you to this session. So all over to you, sir, now.
Okay, good afternoon to all of you. Yes, I'm going to discuss with you Muslim law of inheritance, and here the books that you can use. Of course, you have Faizi, Mullah, you may refer to, and also you will find this law of inheritance in second volume of Amir Ali. But I think the best work on succession law is by N.J. Coulson, Succession in the Muslim Family, Cambridge University Press. So if you can get it, this is the best book on the subject. N.J. Coulson, Succession in the Muslim Family, Cambridge University Press. Now here, in fact, you must have done that. You know, we have two main schools, Sunni school and Shia school. In Sunni also we have got actually four schools, Hanafi, Shafi, Maliki and Hanbali. But then in India, 90% of the Sunnis are Hanafis. So when we use the term Sunni, we mean Hanafi Muslims. Similarly, 90% of the Shias in India belong to the Ithna Ashari school. So when we use the term Shia, we'll be discussing the law of Ithna Ashari school only. Then some basic things I think I should clarify at the outset. Firstly, right of inheritance depends on family ties of a person with the deceased. So the ground for inheritance is family ties with the praepositus or with the deceased. But then among the family ties also, fosterage, of course, is a family tie, no doubt, but fosterage is not recognized as a ground. Similarly, affinity, of course, is a family tie, but affinity is also not recognized as a ground for divorce. So, sorry, as a ground of inheritance. There are only two grounds which are recognized as grounds of inheritance. And they are, number one, marriage, and number two, blood relationship. As far as marriage is concerned, the marriage must be valid. And secondly, the marriage must be subsisting at the time of succession. The marriage must be valid. It must be subsisting at the time of succession. Now, I'm not going to discuss entire law of marriage, divorce, etc., all that you know. But just for this purpose, whatever is necessary, briefly I'll mention. Marriage must be valid. Valid means it must have been contracted with all formalities. It must have been contracted in the absence of all impediments to marriage. Impediments, of course, may be temporary, may be permanent, but then those impediments must be absent when such a marriage is contracted. Now, on the ground of course, degree of validity, at least in Sunni law, we have threefold classification of marriage. Sahih marriage or valid marriage, batil marriage or void marriage, and then fasid marriage or irregular marriage. But then here we have to note that for the purpose of inheritance, the marriage must be valid in all respects. In other words, if the marriage is a fasid marriage or if the marriage is a batil marriage, right of inheritance does not exist. Therefore, if there was any impediment to marriage between the parties, whether temporary or permanent or partial or of any other kind, if there was any impediment, the marriage is bad as far as right of inheritance of the parties is concerned. Although the children will have right of inheritance from the parents, but the parents will not have right of inheritance between them if the marriage was a fasid marriage, or if the marriage was a batil marriage, or if there were impediments of any kind between them. Now, then, of course, next one is that marriage must be subsisting. You will say, of course, marriage is subsisting. It is always clear. It is obvious, but it is not always obvious. If the marriage is subsisting, actually, it will be obvious. It will be always clear. But if the marriage is subsisting constructively, then it may not be always clear. When the marriage is existing, actually, no problem. But the right of inheritance between the parties continues till the marriage is subsisting even constructively. Now, till what point of time a marriage is said to be existing constructively? That depends on the type of dissolution of marriage. That depends on the mode of dissolution. For instance, in case of Talaq al-Hasan, in case of Talaq al-Hasan, the marriage is subsisting till the third pronouncement. You know, in Talaq in Hasan, a Talaq is pronounced once. In the second month, again it is pronounced once. Again, in the third month, it is pronounced for the third time. So, on the third pronouncement, the divorce becomes irrevocable and the wife goes into her iddah. And during this iddah period, there is no right of inheritance between the parties because the talaq has become already irrevocable. But then till the third pronouncement, the talaq is revocable and therefore right of the parties to inherit from each other also subsists. The second form of talaq is talaq al-ihsan, where the husband pronounces a talaq and they separate. The wife goes into her iddah, they separate, and then after 3 months or till the delivery of the child, if the wife is pregnant, the iddah will continue and mutual right of inheritance will be there because the talaq is during this period revocable. They can come together at any time during this period, and therefore the talaq is revocable, and hence mutual right of inheritance also exists during this iddah period. The third form of talaq, talaq al-bain or talaq al-biddat, has been abolished now. It is no more there. It was triple talaq. Now, of course, it is not there. But then in this form of talaq, the wife would go into her iddah immediately. And during this period, no mutual right of inheritance would exist because the divorce had completely terminated the marriage. Then, of course, we have divorce by mutual consent. Khula and Mubarak, both are actually in contract form. They are kind of contracts. So therefore, as soon as they are finalized, they become final and irrevocable. Although certain things may have to be done later, some acts might be required to be performed later, but then a contract becomes irrevocable as soon as it is finalized, as soon as it becomes final. So once it becomes final, the talaq, the divorce is irrevocable, dissolution is irrevocable, and therefore during this period of iddah, no mutual right of divorce, no mutual right of inheritance between the parties. Then we have the doctrine of fast or judicial divorce. Under the classical Muslim law, the judicial divorce was recognized in a way under the doctrine of fast, but then different schools recognize different grounds for fast. And of course, Hanafi school was the most conservative, Maliki school was most liberal, but then those things are only of academic interest because now we have not actually abolished the doctrine of fast, but rather we have on this the Muslim Dissolution of Marriages Act 1939. And there under section 2, grounds have been enumerated, and there are of course fairly large number of grounds. On any one or more of them, a Muslim wife can petition for the dissolution of her marriage. The grounds are, of course, that the husband has been missing for 4 years or more and has not been heard of by those who would have heard of him had he been alive. Secondly, that the husband has failed or neglected to maintain her for 2 years or more. Thirdly, that the husband has been sentenced to imprisonment for 7 years or more and the sentence has become final. Fourthly, that the husband has not been performing his marital obligations for 3 years or more. Fourthly, that the husband was impotent at the time of marriage and continues to be so. Next, sixthly, that the husband has been suffering from some form of venereal disease or leprosy, or he has been suffering for not less than 2 years from insanity. In other words, if he is suffering from insanity, then for 2 years at least, the wife will not have it as a ground for dissolution of her marriage. Although, of course, she can live separately, but then it will not be a ground for dissolution of marriage for 2 years. That means she has to put up with a married husband for at least 2 years. But then this insanity must be certified by a court of competent jurisdiction again. Otherwise, every wife would consider her husband to be insane and would like to get rid of this on this ground. That is not enough. That cannot be done because it has got to be certified by a court of competent jurisdiction that husband has been suffering from insanity and he has been suffering for at least 2 years. This is a ground for dissolution of marriage at the petition of the wife. Then seventh one is that the husband has been repudiated by the wife under the doctrine of option of puberty, that the wife was contracted into marriage before she attained the age of puberty. Now she has attained the age of 18 years and the marriage has not been consummated. So under the doctrine of option of puberty or khayal ul bulugh, the wife has repudiated the marriage and this is a ground for dissolution of a marriage under this provision. And then you have section 2(8), clause 8, where cruelty is recognized, and on the ground of cruelty also, the wife is entitled to get a dissolution of a marriage. And cruelty has been well formulated under this clause. Cruelty means, number one, that the husband habitually assaults the wife or makes her life miserable. Number two, that he associates with women even repute. Number three, that he forces the wife to lead an immoral life. Number four, that he exercises power over her property or prevents her from exercising her right over her property. Number five, that the wife has been prevented or the husband attempts to prevent her in her religious prayers and rites, like fasting, etc. He does not allow, prayers, etc. He doesn't allow. On that ground also, the wife can petition. That is also a cruelty here. And lastly, that the husband has married a second wife and does not treat her equitably. This is also cruelty. And then you have got clause 9, which says, or any other ground recognized under classical Muslim law. So therefore, after enumerating fairly these large number of grounds, also any other ground recognized under the classical Muslim law is covered by the provisions of this act. And there are certain obsolete things which are no more talked about, no more discussed, but still they are available to the wife as ground for divorce, such as ila, zihar, or liyan, etc. On any one of them, the wife can petition the court for the dissolution of her marriage. Now here, if the court dissolves a marriage on these grounds, any one or more of these grounds, and the order becomes final, then it is irrevocable and she goes into her iddah, and during this iddah period, there is no right of inheritance between the parties, between the husband and the wife. Should any one of them die, the survivor will not inherit from the deceased. Now then, quickly, priorities we will pass on to, because next important question is priority in inheritance because a person may not have many relatives when he is alive, but when he dies, and particularly if he dies leaving behind estate, leaving behind a lot of property, then he will have many relatives, he will have many legal heirs, and then question of priority will arise. So in priority, we have always problem. When you get a problem, always you get a problem on priority. Who will exclude whom? Who will exclude whom? Now, by the term priority, of course, we can here have two different senses. Firstly, de jure priority, and secondly, de facto priority. But under law, of course, we mean always de jure priority. That means priority where a legal heir can exclude other legal heirs as a matter of right because of his superiority, because of superiority of his relationship with the deceased. This is priority. This is de jure priority. But then also there can be a situation where the deceased is survived in situation where there are large number of Quranic heirs. We'll see what actually Quranic heirs are, who they are. But then when he has left behind large number of Quranic heirs, and then the estate is exhausted, and then the residuary heirs, the heirs who are supposed to take the residue, they don't get anything. That is de facto exclusion. That is de facto exclusion. But then that can happen sometime. But in law, we don't consider that as a matter of priority of one legal heir over the other, because it is priority only at the stage of distribution of the estate. And when there are too many heirs of a particular kind, of course, others may not get anything. But then it is not actually exclusion because of some kind of superiority of those legal heirs. Then anyway, here we have, in fact, in the context of priority, we have two main types of legal heirs. Firstly, we have agnatic heirs. Agnatic heirs means, of course, male agnates, male relatives who are connected through males. They are all agnatic heirs. And then the second class is Quranic heirs. Agnatic heirs are those legal heirs who are males or who are connected through males. The priority among the agnatic heirs is governed by what is called Al-Jabri's rule. It is governed by one single composite set of rules called Al-Jabri's rules. And Al-Jabri's rules again has three main sub-rules. Al-Jabri's rule consists of three sub-rules. Number one, rule of class. All agnatic heirs are divided into 5 classes. Number one, class of descendants, means sons or son's son or son's son's son, how low soever. Class 2, ascendants, that means father, father's father, how high soever. Father's father, single line of succession, single line going upwards, father, father's father, father's father's father, how high soever. Class 3, brothers, that means descendants of the father, brothers and nephews, how low soever. Class 4, descendants of grandfather, that means paternal uncles, etc., and their descendants. Class 5, descendants of great grandfather. So in this way, you can go upwards, any number of classes you can have, theoretically at least. And here, class 1 excludes class 2, 3, 4. Class 2 excludes 3, 4. Class 3 excludes class 4. Class 4 excludes class 5. So any member of class 1 will completely exclude all members of class 2, 3, 4, 5. Any member of class 2 would exclude completely all members of class 3, 4, 5 under the rule of class. Then next one is a rule of degree. Under the rule of degree, anyone who is nearer in degree completely excludes anyone who is remoter in degree. That means a son excludes a son's son. A son's son completely excludes son's son's son. In this way, the rule of degree operates. Similarly, under this rule, a brother excludes a nephew. Similarly, under this rule, father excludes grandfather. A grandfather excludes great-grandfather under the rule of degree. The third sub-rule is rule of strength of blood tie. Rule of strength of blood tie. Anyone who has stronger blood tie will exclude anyone with weaker blood tie. And of course, this strength of blood tie question arises only between the collateral relatives. Collaterals of the deceased, that means brothers, or collaterals of the deceased father, that means the father of the deceased and his brothers, or collaterals at the level of the grandfather and his brothers. Now, under this rule, the germane brother means both the parents are same, father same, mother same, they are called germane brothers. A germane brother will completely exclude a consanguine brother. Consanguine brother means father is same, mothers are different. Suppose mother has died, the father gets married to another woman and children are born, they are consanguine brothers. They may be consanguine brothers and sisters. So father being same. So a germane brother under this rule excludes a consanguine brother. Germane would exclude a consanguine, that's all. But of course, neither germane nor consanguine would exclude the uterine. Uterine means the same mother, but the father is different. That means the father had died, the mother got married to another man, children are born, they are uterine brothers and sisters. So uterine brothers or sisters are not excluded either by the germane or by the consanguine. And of course, the reason is that because uterines are Quranic heirs, because they have been nominated by Quran. That is the reason. They are not excluded by the agnatic relatives. So this is Al-Jabri's rule, and this is the only rule that we have for governing the succession among all the agnatic relatives. All male agnates are governed by Al-Jabri's rule only. Then the second class of legal heirs are Quranic heirs. The Quranic heirs are those heirs who were nominated by Quran. Quranic heirs Can you hear me?
Yes, sir. Yes, sir.
Because it had there was a blackout. So anyway, yes. So Quranic heirs are those legal heirs I was saying who were nominated by Quran, and under Sunni law, they are 12 in number. Husband, number 2 wife, 3 mother, 4 father, 5 grandmother, 6 grandfather, 7 daughter, next agnatic granddaughter, next germane sister, next consanguine sister, next uterine sister, and last uterine brother. So these are the 12 Quranic heirs who are nominated by Quran. They were nominated by Quran and therefore they are called Quranic heirs. Now, between these two classes of heirs, agnatic heirs and Quranic heirs, the Quranic heirs have to take their prescribed shares because Quran prescribes shares for them specifically, fixed share for them. So they are also called sharers. They are also called Ahl al-Faraid. Now, they have to take their fixed shares. So they should be given their shares first. And then the rest will go to the residuary heirs, male agnates. So when you have to distribute the estate, first you have to give to the Quranic heirs their shares, and then the residue will go to the residuary heirs or to the male agnates. But then you see, the thing is that Quranic heirs are mostly they are inheriting as Quranic heirs. They are inheriting their own fixed shares, but in the presence of male agnates of the same class, same degree, and same strength of blood tie, they are converted into residuary heirs. And then they inherit in the ratio of 2 to 1. That means Quranic heirs do not always inherit as Quranic heirs. They do not always inherit fixed shares. They also inherit as residuary heirs when male agnates of the same class, same degree, and same strength of blood tie is present. Under the doctrine of Tasib, they are converted into residuary heirs and they inherit in the ratio of 2 to 1. So anyway, that we have to remember. Then, of course, apart from these relatives, apart from these legal heirs, male agnates or agnatic heirs and Quranic heirs, others are also there, but they are not called to succession in normal circumstances, nor will it be possible here, I think, to examine their cases in this context because they are too remote. So we will therefore confine ourselves to these two classes of legal heirs, agnatic heirs and Quranic heirs, and we will take them together and we will arrange them for practical purposes into three classes in the way they are normally present, in the way they normally survive the deceased. So we can take these two classes together, agnatic heirs and Quranic heirs, and we can classify them into following three classes. Number one, primary heirs. Number one, primary heirs. Primary heirs are 6 in number. They are husband, wife, mother, father, son, and daughter. So husband, wife, mother, father, son, and daughter. Now, one thing about the primary heirs that we have to remember is that they always inherit if they are present. They can never be excluded by anyone. They always inherit. They are never excluded from inheritance. Now, as far as husband is concerned, husband is a Quranic heir and he is always a Quranic heir. Neither he excludes anyone, nor can he be excluded by anyone. The share of the husband, in the absence of any lineal descendant is 1/2. In the presence of a lineal descendant, it is 1/4. As far as the wife is concerned, wife is also a Quranic heir. She also inherits always, can neither be excluded by anyone, nor will she exclude anyone. And the share of the wife in the absence of lineal descendant is 1/4. In the presence of lineal descendant, it is 1/8. Now, by the term lineal descendant, here we mean a son or daughter, or son's son or son's daughter, how low soever. So, by the term lineal descendant, we mean son or daughter, or son's son or son's daughter, how low soever. In this way, they inherit, the husband and the wife. Then comes the mother. Mother is a Quranic heir. Mother's share is 1/3 in the absence of any lineal descendant. Also, in the absence of plurality of collaterals, it is 1/3. That means the mother is reduced to her minimum share of 1/6 by lineal descendants. The mother is reduced to her minimum share of 1/6 by the presence of lineal descendants. Also, she is reduced to 1/6 by plurality of collaterals. That means if there are 2 or more brothers, or two or more sisters, or one brother and one sister, she is reduced to 1/6. Otherwise, she takes 1/3. And she inherits always as a Quranic heir. The next one is father. Father is a Quranic heir in the presence of lineal descendants. But he is a residuary heir because he is a male of highest priority in the absence of lineal descendants. So in the absence of lineal descendant, he is from class 2. And therefore, he gets top priority if there is no one surviving from class 1. And then he will inherit as a residuary heir. But then if there are lineal descendants, like son or son, etc., then he takes as a Quranic heir. But if the lineal descendants are daughters or agnatic granddaughters, and if they take their shares and something remains, then the father inherits in dual capacity. First, he inherits with them as a Quranic heir, and then whatever is residue he takes again by way of residuary heir. So in the presence of female lineal descendants, the father may inherit in dual capacity. Firstly, he inherits with them as a Quranic heir, and then if there is any residuary, he also takes as a residuary heir the rest, the residue. So he can inherit in dual capacity in this situation. Next one is son. The son is, of course, a male agnate of highest priority belonging to class 1 and, of course, nearest in degree. So if the son is present because he belongs to class 1, he excludes all other relatives. First of all the legal heirs who are lower in degree than him. That means grandson, great grandson, etc. They are all excluded by him on the ground of degree. Then all brothers, etc., all uncles, etc., they are all excluded by him on the ground of class. Because of class, he belongs to class 1, they belong to class 3. So they are all excluded by the son. On the ground of degree or class, they can all be excluded if the son is present. And the son always inherits as a residuary heir. This is the only capacity he has. The son always inherits as a residuary. Next one is daughter. The daughter is a Quranic heir. And of course, she is nearest in degree as far as the prejudice is concerned. So again, she inherits always. But as a Quranic heir, she does not exclude anyone, nor can she be excluded by anyone. And the share of a single daughter is 1/2 of the estate. The share of 2 or more daughters is 2/3 of the estate. The share of a single daughter is 1/2. The share of 2 or more daughters is collective portion of 2/3, which they will share between them equally. But if the son is present, the daughter, as I said earlier, if a son is present, the daughter is converted into a residuary heir, and they inherit in the ratio of 2 to 1. 2 shares to the son and 1 share to the daughter. Now, let us take some examples, some illustrations. I think then things will become clear. Suppose, very simple problem. Suppose the deceased is survived by mother, father, son, and a daughter. Okay. Mother, father, son, and a daughter. What will happen? What will be the distribution? You see, because there are lineal descendants, mother and father all are Quranic heirs, and they are reduced to their minimum shares because of the lineal descendants. So the mother will take 1/6 as a Quranic heir. The father also will take 1/6 as a Quranic heir. So these 2 Quranic heirs will take away 1/3 of the estate. Now remains 2/3 of the estate. This 2/3 will be made into 3 shares because we have to give to the daughter 1 share and we have to give to the son 2 shares. So this 2/3 of the estate will be made into 3 shares. 1 share will be 2/9, right? 1 share will be 2/9. So the daughter will get 2/9 of the estate and the son will get 4/9 of the estate. Daughter will get 2/9 of the estate and son will get 4/9 of the estate. Clear to everyone? Anyone problem? Any problem? Any confusion, anyone? Do I need to repeat?
Students, you can unmute yourself and
Sorry?
ask. No, students, I'm telling to the students, they can unmute themselves and
Yes, they can ask questions.
yeah, they can ask questions. If you have understood or if you have not understood anything, please unmute yourself and
Yes?
anything. The students are very laid back, sir. They don't want to unmute themselves.
Okay, you can ask me later also. But you see, you have to please try to follow. Okay, suppose again, in the same problem, only we are confining ourselves to the primary heirs. Suppose again a deceased is survived by a father, a mother, husband, son and daughter. Okay, just little more addition. Husband is also present here. Father, mother, husband, son and daughter. You see here again, lineal descendants are present. Therefore, father and mother, they both will be Quranic heirs. We have to give to the father 1/6 and mother 1/6, husband 1/4. I said no earlier. Husband share is 1/4 in the presence of lineal descendants. So let's say mother's 1/6 will become 2/12. 1/6, 2/12, same thing. So mother's 1/6, 2/12. Father's 1/6, 2/12. Husband's 1/4, 3/12. So they take away, all three of them will take away 2/12 plus 2/12 plus 3/12. They take away 7/12. All three Quranic heirs will take away 7/12 of the estate. 5/12 remains, right? 5/12 remains. Now this 5/12 we have to make into three parts. 5/12 we have to make into three parts. One part will be 5/36. One part will be 5/36. So the daughter will get 5/36. The son will get 10/36. The son will get 10/36. Now, you see, so this is how you have to distribute the estate when you have only primary heirs present, or at least they are entitled to inherit. Because other legal heirs also may be present, but they may be excluded by these primary heirs, especially when there is a son. So anyway, in this way you have to distribute. Now, you see, but the thing is, sometime the son may not be present, or sometime ignitic grandson also may not be present. And sometime what may happen is that the Quranic heirs who are present, they don't exhaust the estate. That means the estate is undersubscribed. Or the opposite can also happen. Sometimes too many Quranic heirs are present. Sometimes too many Quranic heirs are present. And therefore, the estate is oversubscribed. That is also a problem. So in these two cases, we have to make adjustments. In these two cases, we have to make adjustments. In the first instance, because the estate is undersubscribed, after distributing among the Quranic heirs, still something remains. So you have to adjust their shares. You have to increase their shares. Or they are too many, and therefore the estate is oversubscribed. That means you have to take away something from each one's share. You have to reduce each one's share. That also may be required. Now the first one is dealt with under the doctrine of owl. Under the doctrine of owl, under the doctrine of Rad, I think we should discuss first, that is easier. Under the doctrine of Rad, simply we return the proportionality, we just return the residue. We just return the residue, that's all. So suppose the legal heirs who are present are mother and daughter. Okay, let's take a very simple problem, as simple as possible. Suppose the legal heirs who are present are mother and daughter. The mother takes 1/6, the daughter takes 1 half, 1 upon 2 means 3 upon 6, right? 3 upon 6, 1 upon 2 are same. So mother takes 1 upon 6, daughter takes 3 upon 6. So if you total up, it is 4 upon 6. It is 4 upon 6. That means 2 upon 6 still remains. 2 upon 6 still will have to be distributed between them. So what we do? This 1 upon 6 and 3 upon 6, when you total up, you get 4 upon 6. So this 4 that you are getting by way of numerator, you make it a new denominator. You make this new denominator, keeping the original numerator same. Keeping the original numerator same. So mother's 1/6 will become by way of rad 1/4, and daughter's 3/6 will become by way of rad 3/4. Mother's 1 upon 6 will be increased by way of rad to 1/4, and daughter's 3 upon 6 will be increased by way of rad to 3 upon 4. The daughter will get 3 upon 4. So in this way, you increase their shares just by making the sum total of their shares. The total that you get, you call it numerator. So this numerator you make new denominator, and you keep the original numerator same, 1 or 6, as the case may be here for the mother and the daughter. So mother will get 1/4, the daughter will get 3/4. Clear? Now the reverse also can happen. That the estate is oversubscribed. That also can happen. The estate can also be oversubscribed because too many legal heirs are present who are claiming their shares. For example, a deceased is survived by mother, father, husband, and let us say 2 daughters. Okay, mother, father, husband, and 2 daughters. What will happen? You see, the mother and father will of course take as chronic heirs because lineal descendants are present. Mother will get 1/6, means 2/12. Father will get 1/6, means 2/12. The husband will get 1/4, that means 3/12. That means 3/12. And the 2 daughters will take 2 upon 3, means 8/12. Right? The 2 daughters will get 2 upon 3, means 8 upon 12. Now you add up all these. 2 plus 2, 4, plus 3, 7, plus 8, 15. So it becomes 15 upon 12. So the numerator that you are getting is 15. You make this numerator new denominator. You make this numerator new denominator, keeping the original numerator same. So mother's 2/12 will become 2/15. Father's 2/12 will become 2/15. Husband's 3/12 will become 3/15. And daughter's 8/12 will become 8/15. Now here, of course, their shares are reduced, and also they are reduced proportionately. They are reduced proportionately in this way. And this is called doctrine of owl. This is called doctrine of owl. AWL. AWL. Now here we are discussing the doctrine of Rad and doctrine of owl in the context of primary heirs. But then these doctrines are applicable in other cases also. They may be applicable in cases of substitute heirs or even secondary heirs. So here we have discussed, and therefore we will not discuss them later. So the doctrine of Rad, RADD, the doctrine of Rad and the doctrine of Awl. They are applicable not only in cases of primary heirs, but also they may be applicable in the context of substitute heirs and also secondary heirs. Then now we go to the substitute heirs, the class 2. Second class of heirs, substitute heirs. If you don't have any question, we go to substitute heirs. Now, there are 4 substitute heirs who are substitutes for the 4 blood relatives in the group of primary heirs. That means in the group of primary heirs, there are 4 blood relatives. And therefore, for those 4 blood relatives, we have 4 substitute heirs. They are mother's mother, grandmother, substitute heir for the mother, grandmother, father's father for the father, son's son for the son, son's daughter for daughter. So, grandmother, grandfather, agnatic grandson, agnatic granddaughter. These are the 4 substitute heirs. Now, at the outset, we have to note that substitution is not representation. They are substitute heirs. Means what? Means they are going to inherit broadly on the same principles as their own primary heirs. But then they have their own relationship with the deceased. They have their own relationship with the praepositus. They have their own claim to the praepositus. And therefore, they will not exactly inherit always as the representatives of their respective primary heirs. That will not happen. But broadly, that will be the case. Broadly, that will be the case, but not exactly that will happen. So anyway, now firstly, grandmother. Grandmother is a substitute heir for the mother, and therefore she always will be excluded by the mother. If the mother is present, she will never inherit. She will never come to succession because the mother is there, primary heir, and therefore she is excluded. Otherwise, grandmother, how high soever, maternal, paternal, both. Substitute heir for the mother. The share of a grandmother is 1/6, and she always inherits as a Quranic heir. Neither she is excluded by anyone else other than the mother, nor will she exclude any other legal heir. She inherits always, and her share is 1/6. Next one is grandfather, agnatic grandfather, how high soever. He is a Quranic heir in the presence of lineal descendants, and as a Quranic heir, his share is 1/6 of the estate. But then he can also be a residuary heir if there is no lineal descendant present, because then he is a male agnate of highest priority. If the father is not there, he becomes male agnate of highest priority belonging to class 2, and therefore he can get the entire residue or residue after giving the share of the spouse relic, husband and wife. He can take the entire estate by way of a residuary heir. So he has these two capacities. Either he can inherit as a Quranic heir, and as a Quranic heir, his share is 1/6, or if he inherits as a residuary heir, he can get anything, whatever is left, whatever is there as a residuary heir. Then next one is agnatic grandson. Agnatic grandson is excluded by the son because he is nearer in degree, but otherwise, agnatic grandson is very important legal heir in the sense that he belongs to class 1. He is second in degree, but then he belongs to class 1. And therefore, he also, like son, excludes all other legal heirs of class 2, 3, 4, etc. Of all other legal heirs of class 3, 4, 5, etc. He will exclude because he belongs to class 1. Now, a grandson again is always a residuary heir. That is the only capacity in which he inherits. Then agnatic granddaughter. agnatic granddaughter is a chronic heir and her share is 1/2 of the estate. And for 2 or more agnatic granddaughters, the share is 2/3. But only thing is, if the daughter is present, then she will take her share first.
So you are not audible. So you have muted yourself, I think. Sir, you are not audible. Sir, you are not audible.
First of the state.
Yes.
If the daughter has taken away 1/2 of the estate, 1/6 of the collective fund remains, and that will go to the agnatic granddaughter. But if there are 2 or more agnatic granddaughters, then they will share with among them the 1/6. Then they will share between them. There was some disturbance anyway. So the 1/2 may be available to a single agnatic granddaughter, but if there is a daughter present, then she will get only 1/6, because 1/2 of the estate will be taken away by the daughter. So out of the 2/3, 1/2 is taken away by the daughter, and therefore only 1/6 is left, and therefore she will only get 1/6. But then if there is no daughter, then 2 or more agnatic granddaughters take 2/3 of the estate and share 2/3 equally between them. But then if agnatic grandson is present of the same degree, then agnatic granddaughter is converted into a residuary heir like daughter. She is converted into a residuary heir, and they inherit in the ratio of 2:1. They inherit in the ratio of 2:1. 2 shares to the agnatic grandson and 1 share to the agnatic granddaughter. Now, you see, but then agnatic grandson and agnatic granddaughter, how low soever. You see, it may be great grandson, great granddaughter, but then subject to the rule of degree, they inherit. They inherit. That means a grandson will exclude a great grandson, but of course, a granddaughter will not by herself will exclude a great grandson. If there is any residue left, it will go to him because he is a residuary heir. But the granddaughter will take her chronic share. You see, suppose a deceased is survived. Let us take some examples. I think illustrations to illustrate this. Suppose the deceased is survived by mother, uh, mother, father, a daughter, and an agnatic granddaughter. Mother, father, daughter, and agnatic granddaughter. What will happen? You see, mother and father are chronic heirs, but then daughter and granddaughter, they are also chronic heirs. Okay, so we give to them their shares. Mother 1/6, father 1/6, daughter 3/6, right? Daughter 3/6. But then from this collective fard of 2/3 prescribed for female lineal descendants, 1/6 is left. Only 1/6 is left. So in the presence of the daughter, the agnatic granddaughter will get 1/6. So 1/6 father, 1/6 mother, 3/6 daughter, 1/6 granddaughter. They together exhaust the estate. They together exhaust the estate. The estate is then exhausted and nothing remains. And nothing remains. Let us take another example. Let us take another example. Suppose let us combine primary and substitute heirs both. Suppose the deceased is survived by mother, father, and a daughter. Okay, a deceased is survived by mother, father, and a daughter. What will happen? First, they will take their Quranic shares. Mother 1/6, father 1/6, daughter 3/6. So if you add up, you get how much? You get 5/6. No, you get 5/6. So all the Quranic heirs have taken 5/6 of the estate, and 1/6 still remains. 1/6 still remains, and this the father will take by way of a residuary heir. As a residuary heir, he will take the residue. This is the residue. 1/6 is the residue after giving all the Quranic heirs their shares. So this 1/6 residue will go to the father, and here the father will inherit in dual capacity. First as Quranic heirs with other Quranic heirs, and then because there is a residue here, he takes the residue also as a residual heir. So first he had taken 1/6 as a Quranic heir, and then later he takes 1/6 again as a residual heir. So he gets a total of 1/3 of the estate. He gets a total of 1/3 of the estate, or 2/6 of the estate. Any question, anybody? Any question, anybody? Any question, anybody? Okay, then let us quickly go to the secondary heirs. You see, all other legal heirs, apart from these primary and substitute, they are all in the category of, in the class of secondary heirs. All, that means brothers and sisters, uncles and aunts, all other legal heirs, cousins, they are all in the class of secondary heirs. But then they hardly come to succession. They are hardly going to participate in succession. The only legal heirs who will normally participate in succession are the children of the parents only, or their descendants. That means brothers and sisters or their descendants. So we will examine their position only properly. Okay, brothers and sisters and their children from the class of secondary heirs, because uncles and aunts and their children, great uncles and aunts and their children, great uncles and aunts and their children, they hardly come to succeed, because always someone or the other from these groups will be there. So normally we find brothers or sisters or their children, and they are in the forefront in the group of secondary heirs. So anyway, therefore collaterals, brothers and sisters in the class of secondary heirs, we call them collaterals. Brothers and sisters means full brothers, means both the parents are same. Then consanguine brothers and sisters, as I said earlier, father is same, mothers are different. Mother had died, father got married again, children born, they are consanguine brothers and sisters. Then uterine brothers and sisters, father died, mother got married again, and children are born, they are uterine brothers and sisters. So in this class of collaterals, in this class of brothers and sisters, first question of exclusion. You see, they are always excluded by the father. Collaterals are excluded by the father. They are also excluded by the son. They are also completely excluded by the agnatic grandson. But in the majority view, in Sunni school, that means in majority view, they are not excluded by the grandfather. They are not excluded by the grandfather, but they are excluded by the father, by the son, and by the agnatic grandson, but not by the daughter or agnatic granddaughters. Not by the daughter or agnatic granddaughters, except that the uterine brothers and sisters are excluded by daughters or agnatic granddaughters. Uterine brothers and sisters are excluded by daughters and agnatic granddaughters. But otherwise, they are not excluded by the mother, not excluded by the grandmother, and majority view, they are not even excluded by the grandfather as well. Now, among themselves, the germane brother excludes consanguine brother and sister, but the germane sister does not exclude them. The germane sister does not exclude consanguine brother or sister, but rather she takes her own Quranic share. But she will not exclude the consanguine brother and sister. But neither germane nor consanguine will exclude the uterine brothers and sisters. Why? Because uterines are Quranic heirs. So neither the germane nor the consanguine will exclude the uterines because they are Quranic heirs. So they are not excluded by the germane brother or germane sister, germane or consanguine brother, consanguine sister. No one excludes the uterines. Now, you see, germane brother always inherits as a residual heir. That is the only capacity he has. Then germane sister is a Quranic heir basically, and her share is 1/2. If there are 2 or more germane sisters, the share is 2/3. But if germane brother is present, she is converted into a residual heir, and they inherit in the ratio of 2 to 1. Consanguine brother is always a residual heir if he is entitled to inherit. That is the only capacity he has. He is a residual heir only. Consanguine sister is a Quranic heir. Her share is 1/2. For 2 or more consanguine sisters, the share is 2/3. But then she again is in the same position as a granddaughter, because if germane sister is present, then germane sister gets preference in taking her share. She will take 1/2, and the consanguine sister will get the remaining 1/6. That means the corrective fard prescribed for female collaterals is 2/3, and on ground of course, superior blood tie, germane sister will get 1/2, and the rest 1/6 will go to the consanguine sister in this way. Then the uterine brother and sister, one single uterine brother or sister takes 1/6 of the estate. 2 or more uterines, they get among themselves, between themselves, they may be 2, they may be 3, 4, 5, but they will take 1/3 of the estate and share between them in the ratio of in the same ratio equally. That means they will share, because the principle of taking 2 shares to female to the male and 1 to female is a principle of agnatic succession. It doesn't apply to these uterine relatives. So for a single uterine, the share is 1/6. For 2 or more, it is 1/3. Male or female, they will share equally in this 1/3 of the estate. They will share equally, whether male or female. Now, in this way, therefore, the collaterals, they inherit. But then, as far as the germane and consanguine sisters are concerned, if they are inheriting with a daughter or agnatic granddaughter, then they have one additional capacity in which they inherit, and that is the capacity of accompanying residuary. So with a daughter or agnatic granddaughter, a germane or consanguine sister, if she is there to inherit, she can inherit as an accompanying residuary. That means after giving the daughter or agnatic granddaughter their shares, whatever is there, the germane sister or consanguine sister can take by way of accompanying residuary. And when she is inheriting as accompanying residuary, she will exclude all other inferior agnatic heirs also, like nephew, etc. She can exclude them because she is here inheriting as a residuary heir. She is inheriting here as a residuary heir. She can exclude them. Let me give you an example. Suppose a deceased is survived. Suppose a deceased is survived by a daughter and by a germane sister and by a uterine sister and by a consanguine sister. Okay. So a deceased is survived by germane sister, consanguine sister, uterine sister, and a daughter. The daughter, of course, is a Quranic heir. So she will take her Quranic share of 1/2. But then here, the germane sister, uh, because she is an accompanying residuary, she is getting the residue of the estate after giving to the daughter. She will exclude all other relatives. She cannot exclude the uterines, but the uterine is excluded by the daughter. But she will exclude the consanguine sister on the ground of her superior blood tie. So she will exclude the consanguine sister completely. She will take the half. The rest, half of the estate, she will take after giving to the daughter. Daughter takes Quranic share of 1/2. Residue is half again left, and that will go to the germane sister as an accompanying residuary, and the consanguine sister will be excluded by her. The uterine sister is excluded by the daughter. So half each they will take, the daughter and the germane sister. Now in this way, therefore, they inherit, and also there can be a competition among the collaterals, and there can be serious competition. Suppose brothers and sisters are present in large number, like deceased is survived, let us say, by mother, by husband, and by two germane brothers, by two consanguine brothers, by two uterine brothers. What will happen? Suppose the deceased survived by mother, husband, two germane brothers, two consanguine brothers, and two uterine brothers. What will happen? You see, the mother is a Quranic heir. She takes her share of 1/6. The husband, in the absence of lineal descendant, will take 3/6, 1/2 of the estate, 3/6, right? And then Quranic heir, two uterine brothers will take 1/3, 2/6 of the estate. So 1/6 plus 3/6 plus 2/6, the entire estate is exhausted. The germane brothers get nothing because they are residuary heirs. The consanguine brothers get nothing because they are excluded by the germane brothers on the ground of superior blood tie. Okay, so here, see the competition among the legal heirs. The mother, husband, being Quranic heirs, they take 1/6 and 3/6 each, and then the two uterine brothers take 1/3 or 2/6 between them, and then the estate is exhausted, and the germane brothers get nothing because there is no residue. But then the consanguine brothers are excluded by the germane brothers, and therefore they also get nothing. Any question, anybody? Any question, anybody? Anybody, any question? Okay, I think we should wind up here as far as Sunni law is concerned, and let us quickly go to Shia law. Let us quickly go to Shia law. You see, under Shia law, one important thing that needs to be noted is that their rejection of the agnetic criterion. They outright reject the agnetic criterion. The agnetic superiority that we have is rejected by the Shia school, and under Shia law, the legal position of a legal heir is determined by his relationship with the praepositus, by his relationship with the deceased, and this is called karaba. This is called karaba, Qaraba, and this, under the doctrine of karaba, the relationship with the praepositus is determined with reference to three rules. With reference to three rules. Number one, rule of class. Number two, rule of degree. And number three, rule of strength of blood tie. Rule of class, rule of degree, and rule of strength of blood tie. So firstly, rule of class. Under Shia law, all legal heirs are classified into three classes. They are categorized into three classes. And they are: number one, parents and children and their descendants, how low soever. That means parents, children, and descendants, how low soever. So parents and descendants, you can say, how low soever. Class 1. Class 2, grandparents, paternal and maternal, brothers and sisters, and their descendants, how low soever. So class 2, grandparents, paternal and maternal, how high soever, and brothers and sisters and their descendants, how low soever. Class 3, children of grandparents and their descendants, how low soever, followed by children of great grandparents and their descendants, how low soever, and followed by higher and higher, great great grandparents and their descendants, how low soever. So in class 3, you have many subclasses. You can have as many subclasses as you like. But then these are three main classes. Now class 1 completely excludes class 2. Class 2 completely excludes class 3. So any member of class 1 completely excludes all members of class 2 and 3. Any member of class 2 completely excludes all members of class 3. Then rule of degree: anyone who is nearer in degree excludes anyone who is remoter in degree in the same class. That means a son excludes a son's son, a son's son excludes son's son's son, how low soever. Similarly, a grandfather excludes great grandfather, how high soever. But then in this class 2, where we have grandparents and higher grandparents, how high soever, and also we have brothers and sisters, this rule of degree operates separately. So in the class of ascendants, first you apply the rule of degree and settle the question of priority. And then you come to the class of brothers and sisters and apply the rule of degree there. For example, if a deceased is survived by father's father and mother's father, okay, a deceased survived by father's father and mother's father, and also by brother and a brother's son and a brother's son. How will you apply the rule? First, you have to apply the rule in the class of ascendants, and applying the rule in the class of ascendants, the mother's father will exclude the father's father on the ground of degree. So in the class of ascendant, the question of priority is settled. Only mother's father is entitled. Then you come to the class of collaterals, and there you have brother and another one, brother's son. So brother is nearer in degree and therefore will exclude brother's son on the ground of degree. Now here you have therefore a brother and mother's father inherit in this way. The grandparents inherit with brothers and sisters like brothers and sisters. If they are from the side of the mother, they inherit as uterines. If they are from the side of the father, then they inherit as germains if the germains are inheriting, or they inherit as consanguines if consanguines are inheriting. So here, suppose we have german brother, then the entitled legal heirs are the mother's father, uterine brother he becomes, and a german brother. Now the mother's father, being a uterine brother, will take his Quranic share of 1/6. The residue is 5/6. It will go to the german brother as a residuary heir. Anyway, So in this way they inherit. Okay, under the doctrine of Karaba, the rule of class, degree, and strength of blood tie. The third rule is the strength of blood tie rule, and as I said earlier, it applies only between the collaterals. And here, a germane excludes a consanguine. A germane brother or sister, whether it is a brother or it is a sister, will exclude a consanguine brother or sister. But neither germane nor consanguine will exclude the uterine. So whether it is a germane brother or germane sister will exclude the consanguine brother or sister. But neither germane nor consanguine will exclude the uterine. This rule applies in the class of the collaterals. Now, maybe collaterals of the deceased himself, or maybe collaterals of the father of the deceased, or of the grandfather of the deceased, or of the grandfather of the deceased. In this way, the rule will apply, the rule of strength of blood tie. Anyway, once you settle the question of priority under the doctrine of Karaba, then you go to apportionment, and apportionment takes place in the same way. If the legal heirs who are present are Quranic heirs, you give their shares first, and then the residue will go to the residual heirs. But then if they are lower in degree, lower than the parents and children and brothers and sisters, then you apportion the estate on the following representational system of succession. So whatever the roots will get will go down to the branches, will go to the descendants. So if you are distributing the estate between parents and children, it is fine, no problem. We have seen that earlier. Like parents getting 1/6, and children sharing the residue, no problem. But then if the descendants are of a lower degree, suppose the descendants are son's daughter and daughter's son. Son's daughter and daughter's son. Suppose the deceased is survived by mother, father, son's daughter, daughter's son. What will happen? You see, the mother Quranic heir 1/6, father Quranic heir 1/6. 1/3 they have taken away, 2/3 remain. Now we have here grandson and granddaughter. Okay, but then we have here son's daughter and daughter's son. The daughter's son and son's daughter will be represented by the son and the daughter. That means the distribution here will take place at the level of the son and the daughter, representational system of succession. So the distribution will be at this level, and therefore the remaining 2/3 of the estate will be divided between the son and the daughter, and then their shares will be passed on to the respective descendants. So here the distribution will be, 2/3 will be made into 3 parts. One part will be 2/9. One part will be 2/9. So the daughter will get 2/9, and this will be passed on to her son. So the daughter's son will get 2/9. The son will get 4/9, 2 shares. The son will get 2/9, and this will be passed on to his daughter. So the granddaughter will get 4/9, the share of her father, the share of her father. Now, in this way, therefore, actually, the principle of representational succession is applied. The same thing among the brothers and sisters also. Suppose a deceased is survived, let us take an example, by a germane sister, by consanguine brother and consanguine sister, and by uterine brother and uterine sister. Germane sister, uterine brother, germane sister, consanguine brother and sister, uterine brother and sister. What will happen? You see here, the germane sister, because of her superior blood tie, will exclude completely, she will exclude completely the consanguine brother and sister. But then she will not exclude the uterines. So the uterine brother and sister will take one third of the estate, and they share between them 1/6 each. 1/6 germane sister, 1/6 sorry.
I think there is some network connection on sir's side. Please wait, okay, students?
And uterine brother.
Okay, I think sir got disconnected. Okay, kindly wait. I think sir will join. Okay. Yes, sir. I think there was network issue from your side, or you got disconnected, sir. So you are not audible. I think you have mute. Sir, you have mute. You have to unmute yourself, sir. You are not audible. Sir, you have mute. Yes, sir. Yes, sir. Uh, no, sir. You are not audible.
Is it okay?
Yes, sir. Yes, sir.
Okay.
So your video is off now, and you have muted it.
Is it okay now?
Yes, sir. Your video is off.
Video is off.
Yes, sir. It's okay, sir. If the video is off, it's okay.
I don't know. You.
Yes, sir. Now it's okay. Your video
it?
is off. Just the video is off. It's okay, sir.
Yes, I think seeing is not important. Hearing is important.
Yes, sir.
Information is in hearing only. So anyway, yeah, somehow there is some problem with the video.
Yes,
And,
sir.
you know,
It's okay,
yeah,
sir. It's okay.
yeah. So in this problem, anyway, yes, the uterine brother and sister, they share between them 1/3 of the estate, each taking equally. And initially, the germane sister will take half of the estate, and then the residue she will take by way of Rad. Residue is 1/6 of the estate, so she will take a total of 2/3 of the estate, and the uterines will take 1/3. So in this way, and of course, if they had descendants, suppose again, if a deceased is survived by let us say germane sister's son. If she is survived by germane sister's son, germane consanguine brother's son, and uterine brother's son. Okay, suppose a deceased is survived by germane sister's son, consanguine brother's son, and uterine brother's son. Here, the distribution, first, of course, you have to settle the question of exclusion. The germanes, you have to presume that they are all alive. The germane sister, consanguine brother, uterine brother. So the germane sister will exclude the consanguine brother, and she will not exclude the uterine brother. She will exclude the consanguine brother, but will not exclude the uterine brother. And therefore, the distribution will be same. you see, the uterine brother will get 1/6 of the estate and it will be passed on to his descendant, and the germane sister theoretically will take 1/2 of the estate, but then by way of residue she will get the rest, and this will be passed on to her descendant, and the descendant will take her share. So the uterine brother's child will get 1/6 of the estate. The germane sister's child will take 5/6 of the estate. Actually, I wanted to do a comparative study also of the solution that we can get under Sunni law and Shia law, but I don't know whether you have the patience and you are in a position to accept it. Otherwise, you could solve some problems under both systems, under Sunni law as well as under Shia law of succession. Sometimes the solutions are same. Basically, when the legal heirs are close legal heirs, like when they are mostly primary heirs, the solution is same, like son and daughter, mother and father. But then when the legal heirs are more distant, the solutions can be different also under both systems. Should we take some examples, some illustrations, or you
Yes.
are?
Yes, sir. Yes, sir.
Okay. Okay. Suppose, let us take some examples where the solution is same. A deceased is survived by mother, father, son, and daughter. Under Sunni law, 1/6, 1/6. And now 1/3 gone, and then you have 2/3 to be made into 3 parts. One part will be 2/9, daughter will get 2/9, the son will get 4/9. Under Shia law also, it is exactly the same. Under Shia law also, it is exactly the same. But see, another problem. Suppose the deceased is survived by mother, father, daughter, and let us see, a daughter's son. Mother, father, daughter, and a daughter's son. Sunni law, mother 1/6, father 1/6, daughter 3/6. Daughter 3/6. What about daughter's son or daughter's daughter? A daughter's son or daughter's daughter would be from outer family, not agnatic heir, and therefore will be excluded. And the reason for exclusion is that any daughter's child is a member of outer family, not an agnatic heir, and therefore will be excluded. So we'll get nothing. And then you are giving 1/6, 1/6, 3/6. So the total is 5/6. 5/6 gone to the Quranic heirs, mother, father, daughter. 1/6 remains. This will go to the father as a residuary heir. This will go to the father as a residuary heir. Under Shia law, you see, the child of the daughter is not a member of an outer family, etc. But the child will be excluded by the daughter on the ground of degree. Because the daughter is nearer in degree, she will exclude. And therefore, the daughter's child being remoter in degree than the daughter will be excluded by the daughter. And therefore, the entitled legal heirs will be father, mother, and daughter. And here, the solution will be 1/6, 1/6, and 3/6, 5/6. But then 1/6 that remains will not go to the father as a residuary heir. That will be returned to all these legal heirs by way of Rad. And under the formula that we have seen earlier, mother's 1/6 will become 1/5, father's 1/6 will become 1/5, daughter's 3/6 will become 3/5. This will be the solution under Shia law. Now, another example, suppose a deceased is survived by a daughter and by a brother. A deceased is survived by a daughter and by a brother, germane brother, let us say. Under Sunni law, the daughter will take her Quranic share of 1/2. The germane with the brother is an agnetic heir, and he will take therefore the residue. He will take the residue of 1/2 because that is the residue. Under Shia law, what will happen under Shia law? Same problem. Daughter and germane brother. Will anyone be excluded by anyone? Will anyone be excluded by anyone? Yes? You see, the daughter belongs to class 1 and the brother belongs to class 2. And therefore, the daughter will exclude the brother because she is from class 1 and the brother is from class 2. So the daughter will theoretically take 1/2 of the estate as a Quranic heir, and the rest she will take by way of Rad. So the daughter will take entire estate and the brother will get nothing. The daughter will take entire estate and the brother will get nothing. Similarly, suppose the deceased is survived by a daughter's daughter. A deceased is survived by a daughter's daughter and a germane brother. Under Sunni law, because daughter's daughter is a member of outer family, not a male agnate, not an agnetic heir, she will be excluded. And the brother, being an agnetic heir, he is an agnetic heir, he will take the entire estate. Under Shia law, daughter's daughter, because she belongs to class 1, the brother, because he belongs to class 2, the daughter's daughter will completely exclude the brother. So the daughter's daughter will take the share of a Quranic heir, 1/2, theoretically. Rest she will take by way of Rad. So she will take the entire estate. And therefore, see how the solutions are different. Under Sunni law, the brother gets the entire estate, not the granddaughter. Under Shia law, the granddaughter gets the entire estate and nothing goes to the brother. Anyway, yes, do you have any question?
Students, if you have questions, please unmute yourself and ask.
Yes. If you have any question,
You can just unmute yourself and ask, sir. Do you have any questions? So usually the students don't have any questions till it comes the exam date.
Well, yes, actually, I think, if we were in a classroom, if you are sitting in some auditorium and we were working out, on the board, then perhaps they would feel more comfortable to ask questions rather than here, online. Online, it is difficult sometimes, of course. But then for the time being, I think this is what we can do. Maximum, this is possible.
Yes, sir. This is the new normal.
Yes. So anybody, any question? Yes. If you have anything or if you have any comment, you want to say anything, please.
Students, do you have any comments? Anything you want to ask? Please ask, sir. You can unmute yourself and ask. Okay, sir, I don't think so they have any questions. Usually they don't have any questions. This is the problem with the class.
Okay, then.
Sir, I'm really thankful to you all for gracing your presence to this class. I'm really thankful. Like, I don't have any words like how I can thank you. Like, because, sir, as you are an expert in family law, not only family law, but when I asked you like to deliver a lecture without any hesitation, you have accepted my request. So I'm really thankful to you, sir, for taking out your time in this busy schedule of yours. So I'm really thankful, sir.
So it has been my pleasure. I also enjoyed. At least I could see you. Yes. I could talk to you.
Yes, online. Sir. Like I've made like whole notes. Like it's like a revision for me now, sir.
Yes. Anyway, wish you all the best.
Yes, sir. Thank you, sir. Thank you so much, sir.
Take care.
Yes,
Okay.
sir.
Okay. Okay. Take care. Take
Yes,
care.
sir.
Thank you.
Thank you, sir.